Good morning. This is Kritika, Associate working with Center for Law and Policy Research, Bangalore. This podcast is being recorded on 13th August 2017. In today's podcast, we will talk about CLPR's work in the area of child marriage in India. We have with us Brototi Dutta, Senior Researcher at CLPR, and Disha Chaudhari, Litigation Associate working with CLPR. Brototi, could you briefly tell us about CLPR's intervention in the area of child marriage in India?
Thanks, Kritika. Gender and child rights have been a key area of interest for CLPR. Child marriage is a gross violation of human and constitutional rights to life and personal liberty. Now, if you look at the data collected by census, the census 2011 data tells us that 2% of girls in India were married under the age of 18 years. In Karnataka, 2 out of 5 girls get married before attaining 18 years of age. Now, CLPR started its work on child marriage this year with a mapping of the legal issues involved and the policies that directly and indirectly address child marriage. Our work is being supported by the Center for Reproductive Rights in New York. Our short term goal is to develop a legal and policy brief of recommendations to strengthen existing laws, and our longer term goal is to litigate on behalf of these children to develop an effective and accessible legal framework.
Brototi, could you tell us what the outcomes of CLPR's intervention take form?
Sure. So now CLPR's focus through our work has been on implementation of the PCMA, that is the Prohibition of Child Marriage Act 2006, and on various allied laws that have an impact on child marriage. The study for our report has focused on Karnataka. Of course, there has been a national focus as well, but we have done a lot of our research in Karnataka looking at implementation of the law in Karnataka. And we have done an in-depth study here to understand the scope of the problem. To develop a comprehensive picture, we have sought inputs from various secondary sources. We've met government functionaries, NGOs, and activists, and we've also reached out directly to minor girls whose marriages were prevented. We've also undertaken an extensive RTI exercise to obtain data on this subject. This was followed in May 2017. We organized a consultation where we brought together stakeholders from different parts of Karnataka and also nationally. Noted academics, lawyers, and government representatives attended this. So all these efforts, our research efforts, and also the kind of stakeholder consultations we have done has culminated in us fulfilling our short-term goal of developing a legal and policy brief on child marriage in India. This brief makes detailed recommendations to strengthen the working of the PCMA, the Child Marriage Prohibition Law, and other allied laws as well. Litigation to empower victims of child marriage to fight for their rights. My colleague Disha is going to speak on this later.
Brototi, did you face any challenges while developing the policy brief on child marriage in India?
Well, frankly, our major challenge has been in collecting information through the RTIs. Like I have already mentioned, we did undertake an extensive process. We made applications to 8 to 9 government departments in Karnataka, but it was quite a challenge getting relevant and complete information. And we were asked to resubmit some of these applications because they were not in the correct format. This was quite a surprise for us because the RTIs are supposed to be, a tool for the common person to kind of seek information, publicly available information from the government. But we had to actually personally follow up with all these relevant departments to get the data so that we could, get our information in time.
Brototi, could you tell us what major issues were discussed in the consultation?
So there were an entire range of issues that were discussed, but some of the key things that I can think of immediately and which became a part of our policy recommendations were one was, of course, the voidable nature, the issue of voidability of child marriage. The second was implementation concerns of the PCMA, the Child Marriage Prohibition Law, and also other laws in Karnataka and nationally. And thirdly was the lack of uniformity in the laws that protect adolescent girls from child marriage.
Could you please provide us a few specifics on each of these issues we found regarding PCMA?
Sure. So, under the PCMA, child marriage is not void, but it is only considered voidable, which means that a minor married girl has to actually go to the court and file a petition to nullify her marriage. Now, this is a major concern because very few women, given the kind of social barriers and the kind of social ostracism that they face, it is very difficult for women to use this option at all. Now, this problem has been mitigated to some extent in Karnataka because the recent amendments that have taken place in Karnataka have actually made child marriage void. So, that's a huge step forward, but this needs to be done for other states as well. We also found in the course of our research that the implementation of PCMA was weak. The officers who were assigned the responsibility, they don't receive training properly and are also very reluctant to file FIRs. In fact, it falls on the NGOs most of the times to take up these cases and approach the courts.
Brototi, in conclusion, could you tell us about the issue of lack of uniform age of consent under different laws?
That's a hugely complex area because the linkages between the child marriage provisions under the PCMA and the IPC and POCSO are very difficult to navigate. Stakeholders have, of course, told us time and again the need to bring uniformity between the minimum age of marriage under the PCMA, which is 18 years for girls and 21 for boys, and the minimum age of consent under the IPC and POCSO. So all of these things need to be streamlined. This is, of course, going to be discussed in detail by Disha.
Thank you, Brototi. Hi, Disha. Could you tell us what the ongoing case, which challenges the validity of child marital rape exception, is all about?
Sure, Kritika. So the case Independent Thought versus Union of India before the Supreme Court challenges Exception 2 to Section 375, which is the provision dealing with rape in the IPC. Exception 2 specifically says that a man cannot be prosecuted for rape where the alleged victim is his wife, the wife not being under the age of 15. Now the problem, as Brototi mentioned, is the fact that everywhere else the age of consent for girls is recognized as 18, even within the PCMA and the IPC itself actually after it was amended in 2013. With regard to married girls and especially minors, it says that below the age of 18 to 15 to 18, that age gap too can be exempted from any forced sexual conduct will be exempted in cases of these minor girls. And the challenge is basically, as Brototi mentioned, child marriage is a gross violation of the rights of these girls, and also younger girls are more vulnerable to sexual violence within marriage, and intimate partner violence tendencies are higher in these cases. So we're trying to get the court to read this as meaning 18 and not 15, even in the IPC, to say that where the bride is a minor, you can be prosecuted for rape.
Okay. Disha, could you tell us on what grounds was this exception challenged?
So it's being challenged firstly on its constitutionality, that is with regard to Article 14, because it makes an arbitrary distinction between minor girls on the basis of their marital status as far as rape and sexual offences are concerned. Secondly, 21 with regard to life and liberty, and specifically privacy, which has recently been recognized by the Supreme Court 9-judge bench in Puttaswamy, saying that it gives everyone an autonomy over personal and intimate decisions, and to not give minor girls an opportunity to seek justice as far as sexual violence at the hands of the husband is concerned is depriving them of that autonomy. And thirdly, Article 15 and 39F, which incorporates provisions specifically with regard to children in the Constitution, saying that they should be given an environment which secures freedom and dignity for them to develop. It's also being challenged as contradictory to the provisions of the PCMA. Like Brototi said, the PCMA makes marriages between minors as voidable in law, but they are not to be understood as valid, which was argued by Ms. Jayna Kothari in court, that you have to draw a distinction between a valid marriage and a voidable marriage, and every right that would accrue to a person in a valid marriage cannot accrue to a person where the marriage at some point may be annulled or declared as invalid in law. So to bring it in conformity with the provisions of the PCMA and the POCSO and the Juvenile Justice Act, all of which say that anyone below the age of 18 is a child, and ensure that minors who have been married or been victims of early and forced marriages are not being denied any legal protection from the penal statutes. And also the third aspect has been the international conventions that India is signatory to, which is the Child Rights Convention and the CEDAW, which particularly deal with marital rape and issues of sexual violence within the marriage. And in fact, the Child Rights Review of India in 2014 has given a specific direction to make sure that there is a provision implemented which secures minor girls from sexual violence and sexual offences within the family and the marriage.
Thanks, Disha. Finally, what do you think the verdict on this case would look like?
So there are obviously concerns that have been expressed by the bench itself, because there is the larger question of marital rape, although this case has been limited in its scope to applicability of the exception in case of minors, but it does open up the debate on marital rape as a whole. Secondly, some of these marriages, there may be consensual sexual conduct, and then there's also the issue of children being born out of these marriages. So it's a complex issue to deal with, but Ms. Jayna Kothari had specifically argued in court that the exception be read to say 18, which would mean that it would only apply in cases where a wife is above the age of 18. So if that is done, then we can, at least to this limited scope, see that marital rape is actually criminalized in the case of minors, and we're hoping that's the way the verdict goes.
We hope so too. Thank you, Disha. Thank you, Brototi. Thank you all for listening.